The correct way, I believe, would be to obtain the investigational new drug status license from the federal government, which then allows you, through their license, to formulate a cannabinoid or cannabis-based drug. Is that the way that it goes?
Yes, that's basically correct. And with regard to that patent, there is a great deal of irony, of course, that the U.S. government has that patent. The work originated in the National Institutes of Health, and the U.S. government does seek patent protection on its own inventions, and it did in this case. Within the patent world, there are patents that are related primarily to chemicals, where there's a great deal of chemical synthetic work that's conducted on a particular chemical scheme, and the claims in the patent, that part of the patent that legally defines the invention, is related basically to chemistry. And the recitation that you gave of the types of diseases that can be treated by those chemicals that are defined by the patent, it's very common where in those types of chemical patents, meaning patents that cover just a variety of chemicals, that the pharmaceutical company or the applicant will include an entire laundry list of diseases which can be treated, typically without any particular scientific support. So that it's not unusual to see that. It may or may not be taken as evidence that those chemicals have been shown to produce any therapeutic value. Not to say that they can't or don't, but it's very typical within a legal document for the attorney to try to make the claims as broad as possible to cover as much subject matter as possible. Going back to your original question, if a particular drug candidate is found to be one that the company wants to explore, then an investigational new drug application, or IND, would be the first route